Where there's a will, there's a way. Where there's a will, there's also a corpse. Where there is a wheel, there's a bicycle, there's a car, there can be trains, there can be aeroplanes, everything. But where the wheels are a hearse and there is a will, it is where the lawyers come in. A will is a very necessary instrument, and it is high time that lawyers, all of you are either lawyers or will be lawyers soon, please explain to people the necessity of a will, because without a will, there is going to be chaos. I mean, if you don't have anything, there'll be no chaos. People will not even be able to pay for your funeral ceremony, and they won't care for you. But if you have something in hand, you will find that a lot of worms come out of the woodwork, and everybody wants his pound of flesh or his drop of blood. So a will becomes necessary to avoid problems. Then again, you could draft a will which will create a problem if you're not careful. At one time, I used to think that drafting a will was a very easy thing. In fact, a lot of people have put things up on the net of how to draft a will. I have tried a couple of them, and let me tell you, it is a disaster. You might be able to do a lot of things by getting information from the net, but to write a will by taking information from the net is murder. You will die and you'll be killed again. So please don't. A will is a very complicated thing. And as you start writing wills, you will realize how complicated they are. Of course, if you don't want to make it complicated, then you just the testator comes and tells you, I'm so and so, ABCD, give it to this, that, and the other. You write out a will and give it. That's not a complicated thing. But then you are not fulfilling your duty. You are not being honest with your client. You have to ask your client a number of questions. And you might have to make two, three, four drafts. In fact, while you are making the drafts, the testator, that your client, will change his or her mind. It happens very regularly. In fact, the very first will that I had drawn up, well, the second will that I had drawn up, the first one I had drawn up many years ago. The second one I had drawn up was just a little bit before I completed my LLB. And you won't believe it. Now that is 16, 17 years from now. Even today, the testator is keeping on changing his mind. Even today, the good friend of mine. So he keeps on changing his mind even today. People do change their mind, but everybody may not. There's always the possibility of a codicil or just tearing up the old will and throwing it away, or making a new will and saying that the old one is dead, whatever it is. But a will, I think, is a very necessary thing, and it is the duty of the advocates to impress upon people that a will is maybe the most important document that you can ever make. People might be in for litigation or maybe into contracts or anything, but a will, because it speaks from the grave, that's the words that they use, that a will speaks from the grave. It speaks from the grave, but you are not there to explain it. Finally, and mind you, very few wills, when they go in for probates, are uncontested. All of a sudden, everybody wakes up and says, I want my pound of flesh. So most of them are contested. And because they are contested, if you are drafting a will, you have to make very sure that when the judge reads your will, see, now here it is, when I say judge reads your will, I don't think the judges have time to read each and every will. So they will give it to their associates to make notes or whatever it is to help them decide. The will should be drafted in such a way, because if you use legalese, even the testator might not know what you have written. So use very simple and very plain language, and think as a judge would think by reading your will for the first time. That means the will that you have drafted for the first time. The judge should find it easy to decide what exactly you meant when you executed the will. Remember, you're no longer there. So you have to explain all these things to your client and make sure that the will is drafted so that in case of litigation, the opponents fail and your beneficiaries gain. Now here, many years back, I used to give seminars on wills. On It was called How to Write Your Own Will. I have changed my mind. I'll tell you why. It's a very sad and unfortunate thing. It's very sad, very unfortunate, but people lie. It's become a very common feature. People lie. And if they lie to us when we are making out the will, drafting the will for them, I found that people were lying when they were making their own will, blatantly. And now, if you lie when you are making your will, can you imagine the problems that will occur when your actual beneficiaries are in the picture? It's a very sad phenomenon, but it happens. I remember our own jeweler. He knew I was drafting wills. Maybe I did one or two for his. I'd even helped some litigation matters for him and his colleagues. One day he came over with scraps of paper about 6 inches by 4 inches from a small notepad. It had 32 numbers on it. So he says, I want you to make out a will. I said, whose will? Yours? He says, no, my uncle's. I said, where is your uncle? He's in Calcutta. How can I make out his will if he's in Calcutta? No, I'm telling you what he wants. These 32 numbers that he gave me were plots of land. And he says, you make a will, my uncle's will, where he's willing all these 32 plots to me. I asked him, I said, does your uncle have children? He says, yes. I said, are you sure that he doesn't want to give them to you and not to? He said, no, 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 banado na bas banado. He was under the impression that making a will, he would be able to grab everything on those 3 or 4 pages of paper. People don't understand that that is not what a will is for. And if people can go to this extent, you can imagine what they would do if they were to write their own wills. So I was very keen that people write their own wills, but over a period of time, I have decided that I was totally wrong. Maybe 1 in 100 might be able to write his or her will as it should be written and honestly. But otherwise, every will that we get, it it becomes so difficult to get to the final draft. Not only do they keep on changing their mind, but we find so many flaws in the information that they give us. It's extremely important that you have to go, you have to enter the mind of your client. You have to ask him all the right questions and maybe more and try to. It's almost like cross-examining your own client. They get very upset when you do it, but it's for their own good. I mean, you got to impress upon them that unless they are honest with you and they give you all the yes, when they give you all the information, that's another problem. They want to write their own wills, or they want to get their wills written by the chartered accountants. To tell you the truth, I have yet to find a will written by a chartered accountant which is correct. It might be correct, but definitely not as perfect as it should be, because the chartered accountant only thinks in terms of money. He thinks in terms of the bottom line. He doesn't have any concept of what the law is. Even chartered accountants who have studied law, unless they are into wills constantly, they are not. So, as I said, you have to cross examine your client completely and ask so many questions, thinking about the possibility of litigation and how to avoid it, or if it goes into litigation, how to get the judge to understand what you are saying. I come back to that very simple language. Now, how do we go around drafting a will? Suppose somebody comes to us and says, I want to draft a will. Nowadays, because most of us are communicating remotely, we ask them for the telephone number and the email address. We start off like this. Please give me your name, your permanent address, your age, your occupation, your religion, because religion becomes important in testator instruments. Your religion, and if you are married, the name of your wife, her address, if she's definitely staying with you, your children, their addresses, their ages, date of marriage, date of birth of the children, so that we know whom we are targeting. All these we ask them first. Then we draft out just the first 2 or 3 paragraphs of the will. Now, if you people have got a pen and a pencil before you, or if you can get a pen and a pencil for in a minute or so, I'll have my cup of coffee. I would like you to start making these notes. I do not have any notes with me. I am going to do it as I remember it, especially because if I forget something, some point or the other, I want you people to remind me. Get your paper and pencil and we'll go ahead. We'll go back to the first line in a will. Last will and testament of Mr. XYZ or Mrs. ABC or Miss ABC, whatever it is. So that will be the heading. Then it will go like this. At least that is the way we do it. There can be slight modifications. I, Mr. So and so, age so and so. Please write it down. I, the name, age so and so. This is identification. So whatever identification you can give. So I, Mr. So and so, age so and so, permanently residing at, Or if you're temporarily residing at some place, and give the temporary address as well as the permanent address. As much information as you can give to show that it was the testator who was executing this will and that he was in his right senses. So whatever it is, if you want, he can put in his degrees, or he can say, I've been working for such and such a company, or I've had my business under this name, so and so. And I am in sound mind. If he's physically okay, then write physically okay also. But the mind must be sound. When you are executing, you must have learned it in contract. A person has to be capable not only of age, but even to be in his senses and to know what he's doing. There are times when we draft it in English and the person can't read English, so we get it translated into the language that the person can understand. Normally, it is Hindi or Gujarati or Marathi. So the person who's executing it knows exactly what he or she is executing. So, of sound mind and if it's body, make this my last will and testament. Now, suppose he has or he remembers he has. Suppose sometimes people might forget 20 years earlier. They might have just made some sort of paper on it. So, to say that this is my last will and testament, and I hereby revoke whatever I may have written or may have written earlier as a testamentary document. Put all that aside. That is to as of today, that is trash. As of today, what I'm writing is gospel truth. Then the next paragraph, whether the person wants to leave it to his wife and his children, or to his girlfriend, or to her boyfriend, or whatever it is, please mention the immediate relatives. Immediate relatives would be those who would get a share of your proceeds if you had not made a will, if it is intestate. Suppose you don't make a will, then naturally your immediate relatives would be the ones who would be the beneficiaries. But take the case where you don't want them to be the beneficiaries. So, when you write the will, say that this is my wife or my husband, so and so. You can even say that my husband was a philanderer. He was no good. I did not like him one bit, this, that, and the other. And I don't want to leave anything to him, or leave 1 rupee to him, or maybe 101 rupees, just to show that you are aware of his existence, but you don't want to leave anything to him. Quite a number of Parsi wills have that. I am leaving 101. My own grandfather left 101 rupees to my grandmother because he could not get along with her, and left some 1,000 or 2,000, 5,000 rupees to the servant. The intention was that I'm leaving it to the servant, but I don't want to give anything to my wife because I don't like her. So sometimes you do that. Rupee, mention a person even if you don't like that person, and leave a very small amount so that the person won't get up and say that, I'm his direct descendant. He has not left anything to me. That means he was not in his right mind. He was forgetful at that time when he executed. Otherwise, normally he would have left it to me. So by leaving that 1 rupee or that 101 or 51 rupees, you make sure that the fellow doesn't get anything more. So, list of relatives, the ones who would be beneficiaries if you went intestate. Beyond that, people can't ask for anything. So you mentioned that my wife or my husband married on such and such a day. If a wife, also give her maiden name so that somebody doesn't come up and say, I was his wife. You have to prove that what your maiden name was. So always put in the maiden name also. And I have children, X, Y, Z, A, B, C, D, whatever it is, son, daughter, age, born on such and such a day. Date of marriage also you can include. So you are giving us as much information as possible so that other people don't enter the box. We want to keep all those people out. That is the second draft that you send them. They will keep on changing it, this, that, and the other. Somebody will say no. And we normally write my dear wife or my dear husband. No, I don't want this word to be dear. I just want my wife. Fair enough. नहीं लिखेगा. We won't have it. We will just say husband or wife. And my son and my daughter. No, I don't like my daughter because she married without my consent. So don't write dear daughter. And I want to give 10 rupees to my son and only 1 rupee to my daughter. Fair enough. We'll come to that later. But you want to leave her something, right? So we will do that. So we make that second draft. Now we are coming to who the beneficiaries were. We've come to the relatives. We come to who the beneficiaries were out of those relatives. So we ask them to decide. This decision is like a balance sheet. We tell them it's like a balance sheet. On one side, you put all your assets, everything that you own, even the ring on your finger, which would be removed when you die. Everything you put down on paper. And also write over there anything that you might be get, because you might get something. Your uncle might die and leave you something, or your aunt might die, or maybe you still have your father and mother. So think of those things also. On one side, it will be the assets, that means the stuff that you really own or you will own in the future. That's another thing we must remember. In your will, you must write any other assets that I might own in the future are also included. It's called a residual clause. And on the other side, you make out the list of people whom you want to give things to. And as I said, also the people, immediate relatives whom you don't want to give anything to. Put their names down. And we will find a lot of problems. People will say, no, no, I don't want to leave his name or her name. I don't like him. Or explain to them why you are doing it. We tell them that we are only going to give them 1 rupee. Don't worry. But we have to put it in so that they don't claim anything by saying that the testator was not in his right mind when he did it. He was in his right mind. He was so much in his right mind that he hated you. And that is why he's left you only 1 rupee. So that eliminates a lot of problems. People won't go into testamentary, I mean, suits. They will just go into a petition and maybe pass off like that. So then you have these columns. Then you have to sit with the client and ask them 1, 2, 3, 4, 5, 6 column A, B, C, D, column B. So please tell me one item one, whom do you want to give it to? So then they will say, no, no, item one is a big thing, 5 crores of rupees. I want it to be divided. So then you say, okay, item one divided between A, B, and C. Item B divided between C and D. Item E only to F. Whatever it is. So they will start thinking in terms of what they are going to leave. Tell them that by writing this will, you are not giving things away. This is, and none of these people is going to know what you have written over here, because a will is a private document. I'll come. I might forget this, so I'll just break off and come. Remember to put in the executors. Please remember to put in the executors. A lot of wills I find forget to put in executors, or they put in executors who are incapable, who are not interested. Can be anything. So executorship is very important. And what we do, I mean, a lot of other advocates might not do it, but what we do is we make at least one of the beneficiaries as an executor or an executrix. I'll explain why. Suppose you made a will and you want to distribute everything between a few people, your relatives. I am made the executor. You might think that I am an honest man, but I'm not. I'm a crook. Suppose a third party gets in touch with me and says, don't execute this will. Do you know what will happen? I'm within my rights to recuse myself. Or I can say, I'm sorry, physically, mentally, I'm not capable of executing this. Please forgive me. मैं जाता हूँ. What will happen is the court will have to appoint an administrator, and things might drag on. Who knows how the administrator handles the whole thing? So, what I believe in is make one or two, or if you've got just two or three beneficiaries, make all of them executors and executrix, so that they will execute the will in their own interest. Now, remember, people might tell you that no, you can't make a beneficiary an executor. That is wrong. You can't make the beneficiary a witness to your will, because otherwise they'll say, yes, this is signature is right. You can't make them a witness to your will, but you can definitely make them an executor or the executrix. You can even appoint somebody else. Now, suppose you have got children who are maybe 10, 12 years old. Obviously, you can't make them executors or executrix. But you can say that if I survive beyond their age of minority and they become my majors, they should be also made executors of my will. Personal interest, they will try to push it through as fast as possible. So at least I believe in making at least one or two of the my own will. I have made my wife an executrix. The first executrix I made, her will, she has made me the executor. We have got two or three other people in mind. We've got two or three people on paper, but each of us. Suppose, and we've had cases like that. We've had cases like that. One very interesting case which normally I talk about. Extremely interesting case. In fact, I talked to the gentleman just yesterday for another trust that he is forming. He wants me to do that document for him. One of those clients who would never lie. He would be extremely honest in whatever he said, which made things very easy for us. It was almost a hopeless case. People put their hands up. The biggest of solicitors said it's not possible. In fact, a couple of very big solicitors, whom I knew, also told me that Bapoo, forget it, won't be done. In fact, it came to us because my wife's friend one day came and said that there's a very, very nasty case and nobody wants to take it up. Will you people take it up? We said, sure, we'll do it. There was a very big problem with the executors. There were one executor, one executrix. The executrix had a problem, a mental problem, which I do not understand even today. Why her husband put her name in when he was aware that she had a problem? For some reason, he put it in. It was a very big flaw. He also had his friend put in as an executor. The man, as soon as the man died, the testator died, the executor started selling off properties. And when we came into the picture, we were not at all happy with the amount he showed as receipt from properties he was selling. And when we questioned him, he recused himself. Now, mind you, two people as executors, one executor, one executrix. The executrix is incapable. Everybody knows she's incapable. She herself had never taken an interest in it. Why she was put in, we don't know. The executor recuses himself because he doesn't want to answer our questions. What happens to the will? Obviously, nobody wanted to touch it because it would be. We found a few other flaws also later on, but this was the major flaw. We took almost a year and a half or 2 years before we petitioned the court. We went through a lot, hell of a lot of exercises, and drafted the petition in such a way that we had covered all the all the pitfalls, all the loopholes, everything, including making ourselves aware of an advocate who wanted to get in on the picture. He came to the court on the very first day, uh, asked for blatantly asked for a few things, and we told him that he'd better get lost immediately, otherwise there would be problems. So we got rid of him also. But now, what do we do as far as executing the will was concerned? Fortunately, the will had three major things in the will. One was the wife's life interest. The husband, fully knowing that the wife had a problem, still wanted her to be looked after. He was very, very considerate and very fair. He still wanted her to be looked after. So it was a life interest. Anything that came from his assets had to be spent on the wife, which we are even doing till today. Now, this is an 8-year-old story, 9-year-old story, but we are doing it still. Today, we are doing it. We are giving her all the money that we get from the assets. We are giving it to her, not sale, whatever interest we are getting, because she has a life interest. He had also said that if my son survives my wife, the son was highly diabetic, highly diabetic. If he survives, everything should go to him and let him do what he wants. But because of his health, if he predeceases my wife continues with the life interest, and everything instead of going to my son goes to my nephew, who's the only relative left. And it is the nephew who had come to us. So you can imagine what we had to do for maybe a year and a half or two, I don't remember. We had to lay, what they call laying down the planks for the stage. Only after that we went to court. We knew we had a very big problem in front of us. We went to the court. Very fortunately, in just two hearings, our client was appointed an executor, which I believe was the first time in history that it was done. They would have had an administrator or some. We explained to them that an administrator will be disastrous in the sense that it will take too long. And we have here the only beneficiary of the will. Please let him execute it in his favor after his aunt dies. Little bit of exchanges with the judge. I was called into chambers. A lot of things happened. But finally, he was appointed an executor, and the probate was given in his favor. Now, can you imagine? Another problem in that will. The assets were not completely. Maybe the assets were acquired after the will was made. That's quite possible. But because there was only one beneficiary and the residue clause was not included in the will, yet automatically the residue would come to the nephew. He had invested good money, and we did not. We did not know what he'd invested in. So letters would come from the companies in which he had invested, from which we were able to build up his whole estate. And then, of course, we started administrating that estate, and we are still administrating it in favor of the aunt. But I believe that a 40,000 rupee investment had become 28 lakhs, and people were thinking of the estate being only 6 lakhs. So you can imagine how deep you have to dig into these things and how involved they are. So a will is not an easy thing. I would rather draft a, well, I don't like drafting planes, but anyway, I would rather draft a plain or a defense statement, which people call a written statement. I would rather be do that than be involved in a will. It's extremely complicated. And if your client is not on, a lot of people will come and tell you, I want a will to be made for my father or my mother. Fair enough. Where are they? No, they're at home. Yeah, why don't you call them over? No, they are not well. Then maybe go and talk with them. No, you don't can't. Don't talk to them. They are too old. Arre bhai, if they are too old, then how can I make a I mean, I can draft a will, but I'm definitely not going to put my name on the docket. You can do whatever you want with it. If I cannot speak with the testator, if I do not know what shape the testator's mind is, what the testator really wants to do, and in that case, obviously, I refuse. My own cousin, we grew up as children. I knew him for 70 years of his life. He was undergoing dementia, but there were lucid periods. So I spoke with him and I said that, look, I'll come over, but I must make sure that you are in your lucid period. Said and he was always telling me, says, I want to leave everything to my wife. There was no dispute about that. He always wanted to do that. So one day I rang him up and he was abroad. We had come to Bombay, so I rang him up and I asked him, I said, and we talked and I said, look, now this is your lucid period. If you want to get that will done, we must get it done now. Next morning I was at his, we sat down to write down the will. The wife came to the table and she wanted to be in there while the bill was being drafted. I said, you know what your husband's mind is, but I cannot have you sitting here while it is being drafted and you dictating what should be written. In fact, years of friendship were broken up that day because I refused to draft the will if she was sitting next to me or next to her husband. I said, I'm sorry. I said, suppose it goes into litigation. No, my children won't. Maybe your children won't mind it, but their children's spouses might mind it. They might have some problem with this will. We don't want to go to court and say that you were dictating the will or you were around. And especially you were around when everything was being given in your favor. I said, I cannot do it. I'm sorry. And 70 years of friendship went down the drain that morning. But I had to stand my ground. So you can imagine how much of problems there are in executing a will which will stand up in a court of law. There are other things also which do come up. Now getting back to the will, we know the assets and the not the liability, assets and the distribution ABCD, and somehow or the other, the testator has come to a conclusion. Normally they don't; they keep on changing it, but whatever it is, they've come to a conclusion. So we write this goes to so and so, this goes to so. Very clearly you must mention it. And please write the full names. Don't say it will go to Pinky or these pet names and all that. It becomes extremely difficult for a judge to realize who Pinky is and who Sunny is or who Bunty is. So please write the full name very clearly, preferably with the age. So it goes to this. Once you have done that, you come to the executor's part, which we have already discussed. You will appoint executors. We prefer to have at least one of the beneficiaries, if not more, as the executors and executrix with somebody whom you can trust. Who knows? A family traveling together, uh, meet with an accident, all of them perish. We might have, it's always better to have people who are not very close in contact, not who are, doing things together. Might be at a little bit arm's length. It might be happen better to have an executor or executrix for that. But as I said, please keep that clause in that if they want to, they can appoint other executor or executors. So please keep that clause in so that at the last moment, suppose somebody finds it's difficult to execute the will, they give it to a person who's capable. So please keep that clause in. So we have the a lot of people forget to put in the executor clauses. Huh? A lot of people forget to do that. It just slips their mind. Then, again, we already discussed this residual clause that whatever I might receive in future and which I've not mentioned right now should go to so and so, so and so. But in the residual clause, please try and make sure that you don't again distribute those things to 100 people. I'll tell you why, because you never know what the residue will be, whether it will be in terms of liquid assets, whether it will be in terms of property, and then if you say that I want it to go to X, Y, Z, A, B, C, D. Now imagine 7 people distributing distributing an apartment because you might have got the apartment after you made the will. Now we can't break it up into 7 pieces. So it's better to leave it to 1 or 2 people only, just to make sure that there are no hassles in the distribution. but each case you will have to decide on its own merits. That's why I now say I am against people writing their own will. It doesn't work.
What about shares?
Yeah,
Shares
we
and holding.
liquid shares. Liquids you can distribute to 10 people also. It's just a matter of selling everything, dividing by 10 and distributing equally. Or 50% to 1%, 25 to so and so so and so. Liquid assets. But try the residual clause, try to keep as few beneficiaries as possible. It might lead to problems later on. It might also lead to problems of whether it is valued properly, whether it's not valued, whether you all sorts of things can happen. As I told you about that one of the executors recusing himself. He had sold the property, and we know he had sold it for a song. What could we do about it? Nothing. Now, this is a very telling fact, and we know a lot of old people who have been using this. I call it a trick. They are owners of a flat, old people. I go to the person, auntie, I will look after you. I will give you this. I will give you that. So the auntie makes a nomination in my favor. My brother goes to her and says, Auntie, you don't remember me. We grew up together. We had you had so much love for me. I had so much love. Because if he comes to her and says, make me a nominee, I make a nominee, will look after me. Auntie dies. 10 nominees get her. So I go and tell Auntie, I love you very much. Auntie this, Auntie that. Give her a box of chocolates, some sort of thing. And I tell her, Auntie, now we are getting very old. Why don't you make me a nominee in your flat? So Auntie makes me a nominee. Acha. Now we were talking of that auntie who has made 10 people her nominees. Except for West Bengal, in all the other states, the nominee has no right to the property.
West Bengal too.
And now even in West Bengal, they've come in. Divya tells me that the rules have been changed in West Bengal also. The nominee has the privilege of spending money. This is a problem which will crop up in every place where you are making a will. The will overrides everything. If there is no will, if the person dies intestate, the flat will be divided or given to his legal heirs only, not the nominees. Nomination, if you are not in the line of succession, is nothing more than a piece of paper. In fact, it is worse than a piece of paper because it acts as a bridge between the person who owned it and the person who would receive it. The court will decide, not the secretary. A lot of secretaries do it. Nomination hai, chalo, तुम्हारा नाम पे लिख लेता हूँ, 25,000 रुपया ले लो. No, it's immovable property. The secretary has no right to distribute it. If there is a will, the nominee will only hold that property in trust. He will make the payments. Of course, he can recover the payments later on. He will make the payments to the society. Because otherwise, people say, Mera naam likho, otherwise I'm not going to pay you. Society can't be held to ransom. That way, just as the society can hold you to ransom. So the bridge is the nominee, keeps the cash flowing to the society, keeps everything alive, and finally either the court decides or if the will, see, it's only in Bombay this would happen. Elsewhere where there is no probate, the will would be held as an instrument of succession. Please understand, nominee only as a nominee, and no right at all. Might have it as a beneficiary, it's a different thing. So when it comes to a flat, please mention very clearly that this flat must go to so and so. Full name. If you want to give it to two people, okay, say both. But if you give it to two or three people and the flat is same, one bedroom, hall kitchen, one BHK, how are three people going to live there? So say that in this case, I give the right to so and so to liquidate it, and the proceeds to be divided either one third each or whatever the ratio you want to do it in. Please remember that. We get a lot of things where a flat is given to 10 people. Well, not 10, but at least two or three, and nobody knows what to do with it. Finally, it becomes a contentious issue between the beneficiaries. Somebody says the flat is worth 1 crore, somebody says it is worth 10 crores. What do you do then? Finally, if you go to court, the court will say, okay, you say it is 10 crores, buy his share. You say 1 crore, okay, sell your share. Some sort of thing like that. So be very specific and don't sort of make kachubar out of it. Don't mincemeat it. Thing like a flat or a property, try to keep the beneficiaries as few as possible. Alternatively, sell the thing and give the cash to everybody you want. You can do that also. I think now we are coming into the age of reverse mortgages, so that might also work. Now we come to the last part. The testator does not want to put any pressure on the beneficiaries and also wants to make sure that in old age people fall sick last few months or last few years or whatever it is. We are also getting the concept of a living will now, but I don't want to discuss that just now. You can always put in a clause saying that in the last 6 months or last 1 year, all my medical bills will be paid out of my estate by the executors. All my funeral expenses will also be. See, the thing is that people are scared. Suppose I fall ill, I'm not in a light frame of mind or body to take care of myself, and my relatives might fight over who has to look after me. So let it come out of my will. I'm out of my estate. So you put that in saying that the money spent on my hospitalization and my funeral, because everybody wants a grand funeral, and you are not around to make sure that it is a grand funeral. So whatever expenses would come out of my estate, you can put that clause in also. Beyond that, you would have the clause for your signature while executing it. So you will write over that I so and so, so and so, so and so, execute a testator and your signature. Then we come to one more problem, which a lot of people make mistakes on this. When you are executing the will, that means you are signing on the will, you should have two people witnessing the signature. Now, people say it must be a doctor and a lawyer. Not necessary. If it's a doctor and a lawyer, fair enough. But it must be a person who knows what he or she is doing. So you have those two witnesses. Now, as I told you, prescribed and proscribed. The prescription is witnesses. The proscription, that means proscribing witnesses, cannot be beneficiaries. Otherwise, the will get thrown out. Witnesses have to be at arm's length. They are no more than being called to court one day and saying that, yes, I was a witness to this particular will. Now, mind you, a lot of witnesses are very inquisitive. They want to read what is in the will. No, no, I won't sign it. Boss, you are signing it as a witness, nothing. No, I want to read the will. If you want, you can let him or her read the will. But if it's an awkward witness, better to keep them out. They might create problems for you in future. So when you call the witness and say that I am going to execute a will, I don't have to show it to you, but you have to witness my signature, that it is my signature on this piece of paper. He might say, how would I know later on? Give me a copy. Maybe you can give him the last page. He does not have to have everything in it. So the witnesses see you executing the will. That means you're signing the will. Now, suppose you have only one witness ready. That witness executes it. Signs it, saying that yes, execution. What about the second one? The law allows you to inform the second witness that, look, I have executed a will on such and such a day. I'm sending it to you. Please sign it as one of the witnesses. That sort of a leeway has been given. So, of course, it's better to have both the witnesses, or have one witness sign it, go to the next witness and say, look, this is my signature. Please attest it as a witness. That is also a possibility. So this witness clause, this having witnesses, be careful. What we do is, in fact, I did not know about it for quite some time, because before studying law, I did not know about it. But any witness, I would get them to sign an affidavit with their own photographs on it, saying that we have seen the execution of this particular will on such and such a day, such and such a time, etc. I'll tell you why. I don't want witnesses to hold the beneficiary to ransom. Suppose the witness says, "Nee, mera signature hai nahi, I don't know who it was." Then you have to go and get 27 signatures. He might refuse to give you specimen signatures. You might have to go to some bank or something to find out whether the witness could act awkward. Fortunately, and which, as I said, I did not know about it before I studied law. The Bombay High Court has a format. So get that format signed by the witnesses within a year or within 6 months or whatever it is, whereby they say that yes, we had seen. It's a sort of a backup. You are making it doubly sure. Keep that also ready, and then give those to your beneficiaries or whoever your executors are, so that in case the matter goes to court and it's disputed in court, these two affidavits will stand in good stead. Beyond that, don't make too many copies of the will. Make only a few copies, only that which are necessary. You could give sealed copies to your executors. Tell them that this is a sealed copy. Open it when I die, and keep it with you. Open it. Sometimes you might tell the beneficiaries what you have written in the will. It's your wish. You can do it. Finally, the question that arises more in everybody's mind is, should I get the will registered? Well, my contention is yes and no. There is nothing wrong if you get it registered. Sorry, if you do not get it registered, the will is still valid. But suppose you lose the will, suppose it's in some safe, some place where the people can't find it. Then, if you have got it registered, you can get a copy from the sub register of assurances, and that would be as good as your actual will. For that reason, registration might be good. Registration, should it be the same two witnesses when you take it for registration? To be on the safe side, yes, because otherwise there could be another dispute. If you are going to get it registered immediately while the two witnesses are alive. If one of them dies within a year and you want to get it registered with another register, even the sub register of assurances might refuse to do it. It might create problems. So if you are going to get it registered as soon as possible. Then another question arises. Suppose I want to change my will. Everybody is entitled to change his will at any given time, even after registration. Should my next will or my codicil also be registered because I got my will registered? The law is quite clear on this. In fact, I think it's a Madras High Court judgment. There is no need for any subsequent document also to be registered to make it effective. Because at the last moment, you might want to change a few things in the will. You might lose some property, gain some property, whatever it is, and you don't have the time to go to the register. Does it mean that the codicil or the next will that you have made is useless to be torn up and thrown away? No, it overrides the registered will. So the thing is, if you have registered it once and if you have the time and the facility to get it registered again, please get it registered again so that there is no conflict. People don't come up with all sorts of arguments. But the law is very clear on this. Any subsequent instrument also need not be registered. Because see, people in Mofusil areas in villages, you ask them to make wills. You say it is necessary. You want them to make wills so that there are no disputes. And at the same time, you tell them that go 200 kilometers away and get it registered with the two witnesses. Practically, it might not be possible. So that is why if you can get it registered, get it registered. If you can't get it registered, it's quite okay. It depends on what the situation is. The lawyer would be the best person at that time to tell you what you should do. This problem of registration is as common as the one for nomination. It will come up every time. As lawyers, you have to be ready to answer the questions that your client, the testator, wants you to do. I think beyond that, I can't think of anything right now.